Thank you, Chair. I have further questions about NZYQ, in particular preventative detention orders for the benefit of officials. Ms Sharp, I think this will be one for you in the first instance. It's still the case, isn't it, that the government has yet to apply for its first community safety order, isn't it?
That's correct, Senator.
And it's still the case that the government has yet to apply for its first preventive detention order. Is that correct?
That's correct, Senator.
Thank you. We could enter caretaker as soon as tomorrow. What happens in caretaker provisions if a minister is required to make a decision to apply for a CSO or preventive detention order?
Senator, as you'd be aware, during caretaker, the ordinary business of government goes on. If we were in a position to file at that time, we would need to seek the minister's agreement to the filing. That I don't think would be a decision that binds a future government, insofar as if a future government came in and disagreed with that, it would be quite straightforward to simply withdraw the matter from the court. And on that basis, I don't think we would be delayed by caretaker if we were in a position to file it at some point during the caretaker.
Is the minister required to consult with the opposition before making that decision?
The caretaker conventions are entirely silent on litigation matters. The caretaker conventions talk about considering consultation if there's a major agreement, a major policy decision, international engagement, I think. So I don't think that the minister would be required expressed by what's written on the page in the caretaker conventions to consult, but obviously I'm not the minister. The minister might take a different view on that.
Secretary, have you had any conversations with the minister about these sorts of issues and how to manage it in caretaker?
We have talked with him generally about the sort of ongoing business of government during caretaker, and I think for me, as Ms Sharp said, it's ultimately the minister's decision, but in terms of our advice, I would be swayed by the fact that, as Ms Sharp said, I don't believe it would be committing a future government. So to me, it is more like the ongoing business of government than a major new initiative, but not my call ultimately.
Okay. Is this a kind of theoretical question, or is there a possibility that we may be close enough to a community safety order or a preventive detention order that it could fall within the caretaker?
Senator, I believe you'll probably understand when I'm not going to make any commitment about when one might be ready.
Fair enough. I'd understand why you'd be reluctant to do that. We have previously discussed, though, predictions and hopes and possibilities. Are there any that are close to the threshold?
We've also discussed the 3 years that it took the coalition to seek an order under a similar scheme.
You don't need to be sensitive about this. We're just asking factual questions.
Talked about what we've talked about previously. So.
Are there any CSOs or preventive detention orders that are close?
We have had, I think it's currently 12, have gone to experts that we're working through and considering the merits of community safety supervision orders in respect of. To say they're close, they're in various stages of development.
Right. So those 12 that have gone forward, they're only CSOs, they're not preventative detention orders?
That's correct.
So there's no realistic prospect of a preventive detention order coming forward anytime soon if they haven't got to that stage, is there?
No, to go for so I should say when we put one to an expert, we haven't, at that point in time, we don't know whether it's a supervision order or a detention order. That's why we go to the expert, because we're asking the expert for their view on the risk of that person committing a serious violent or sexual offence and what is the minimum set of conditions necessary to manage that community safety risk. So once it comes back from the expert, we then have a view from the expert evidence about whether supervision, some combination of supervision conditions will be sufficient or would be sufficient, or alternatively, the other scenario, as we're getting more used to the scheme, is the conclusion that the bridging visa are conditions can work effectively.
But it sounds like from your answer previously that it's not likely that any of these would meet the threshold for preventative detention, or that additional work would be required for it to meet that threshold.
That's right. I don't have any that I'm looking at that I think that's a detention. Like I've said it several times. It's an incredibly high threshold to be able to take someone who's living in the community, who's not on remand for committing a crime, who's living in the community, and say, we're going to detain you before you commit any crime.
But some of these detainees are on remand or on bail. So would the case be stronger for those ones?
Certainly someone's behaviour in the community since their release from immigration detention is highly relevant to, past behaviour is one indicator of tendency or future behaviour. Yeah,
and some former detainees have been charged with quite serious crimes, and some of them have been charged multiple times with crimes or offences. Isn't that sufficient grounds to make a case for preventative detention?
It's relevant. I don't know that I would say it's sufficient grounds. We don't. There's many people in the Australian community who have committed crimes before who aren't subject to preventative detention.
Yeah. We discussed at the last round of estimates the possibility of legislative change to facilitate these applications to make them easier, and you talked about the different considerations as to whether you could do that or not. Has the Minister requested a brief on any legislative amendments?
I talk with the Minister regularly about the progress we're making under the CSO scheme, the kinds of issues that, the challenges and the individual cases and the like. In terms of a written brief on legislative amendments, I don't think so lately. I don't think so, but I can take on notice.
Okay. So the Minister hasn't said, gee, this is frustrating, this is taking so long. Is there any legislative amendments we could make to facilitate it, to speed it up, to make it easier?
Certainly, as I said, the Minister and I talk regularly about legislative amendments to a range of provisions in the Migration Act, and I would absolutely say we've had that kind of conversation. What I was hesitating at is have I submitted a written brief. That would typically happen at the very end of the legislative design process once we're close to seeking approval of text.
The Minister hasn't asked you to go and draft or consider amendments.
He's not since the last estimates hearing.
Right. What about prior to the last estimates hearing?
We have considered what amendments could be made to the scheme, and we did that in the context of the lead up to the YBFZ High Court case last year, when, as you know, the Bridging Visa R scheme was being considered. The legislation the government ultimately brought on after YBFZ allowed us to continue Bridging Visa R conditions, which, while the Bridging Visa R condition test is substantially higher than what it was before YBFZ, it is still a much more efficient process for placing conditions like electronic monitoring on an individual than going via the CSO scheme. So at the moment, our primary mechanism for managing community safety risk is the Bridging Visa R scheme.
Okay. Can you give me an update on the total legal costs incurred on this, including the management of community safety orders and preventive detention orders?
Just for clarity, do you mean by this, do you mean the entire NZYQ legal cost or the CSO scheme? The
CSO scheme first, and then let's ask the broader question.
I can. So, year to date, this financial year to date, the legal expenditure on the CSO scheme is $13.9 million.
And prior to that, because I think we had a total figure last time I asked about it.
In 23-24, it was $8.1 million.
Okay. So, at the risk of humiliating myself, it's about $22 million.
Yeah, $21.9 million.
We'll say that's close enough. Thank you.
Not humiliating.
No, thank you. And more broadly on the management of the NZYQ cohort, which would include the High Court cases and all the rest.
Legal costs?
Yep.
So year to date, we have expended $20.1 million. This is inclusive of those CSO costs.
Yeah, understood. And last year?
12.8.
Right. Is that the total expenditure, or was there some expenditure in the prior year?
No, NZYQ occurred in November 23. So.
Oh, and you're using financial years?
Yeah, I'm using financial years.
Okay.
So financial year 23-24, $12.8 million.
Yep.
And financial year to date of 24-25, $20.1 million.
Okay, so just short of 33 million.
That's correct.
Thank you. On the deportation of the 3 NZYQ individuals who've been granted visas to Nauru, what's the current status of those legal proceedings?
The current status of the litigation?
Mm-hmm.
So there's 3 individuals who between them have filed 5 matters,
yep.
And there's a further 6th one, an additional one that's foreshadowed, and all are before the courts.
Yeah, what's the 6th one?
The 6th one is, hang on, I'll just... Sorry, I'm just trying to pick out which is the one that's foreshadowed.
That's okay.
That is the matter of CYB 25, and the Minister for Immigration and Multicultural Affairs, and it is in the Federal Circuit and Family Court. This individual is initiating a second proceeding challenging decisions made under Section 198 AHB of the Migration Act, which relate to the decision to, which relate to the Commonwealth taking action in relation to the third country reception agreement. So he's challenging whether there should have been procedural fairness afforded to him when the Commonwealth made an application for a visa on his behalf.
Right, so he's not part of the 3 though.
So he is one of the 3.
Right.
So
but has a separate action.
Yeah, so
right,
each of the individuals have each got 2 matters on foot challenging different things
Understood.
in the system.
Right, okay, that makes sense. Are all 3 of these individuals still in immigration detention as they were last estimates?
Yes.
Yep. And an aspect of their challenge is to the validity of their detention, isn't it? No? No, so their lawyers are not seeking that they be released prior to the consideration of this matter?
No, they're not.
Okay, well that's something, thank you. How many other individuals are being considered for deportation to Nauru?
Senator, as the Minister noted previously, this is an initial cohort that we're considering.
Yep.
As this works through the system, so to speak, further people will be considered, and we have ongoing discussions with the Government of Nauru around the future of the arrangement.
So the Government of Nauru has not issued any more visas to this cohort, is only those first 3, and there's no plans to issue new visas to any more of the cohort?
At the moment, Senator, that's correct.
Are we waiting for clarity about the legal proceedings before we move to further visas being potentially issued, or...?
That is one of the factors, Senator, but again, we're having ongoing discussions with the Government of Nauru around next steps.
Because even if the legal matters remain on foot, which they may for some time, this could take quite a bit of time, the advantage of Nauru issuing visas to other members of the cohort is that they could be taken to immigration detention, which I think the Minister's publicly said is part of the rationale here is that they're off the streets and in immigration detention and leaving the country, we hope. So that's not under consideration?
It is currently a matter for the Government of Nauru to grant visas.
Sure.
So we are, again, discussing with them next steps. Okay,
so we're in negotiations actively with the Government of Nauru about issuing more visas?
Yes, that's correct, Senator.
Okay. And what are the timelines for that consideration?
No specific timelines, Senator. It is an active, ongoing discussion that's occurring at the moment. Right.
Is one of the considerations the payment of money from the Australian Government in exchange for that?
Senator, as we mentioned at the previous estimates, there is a cost and a financial discussion, yes. the detail being subject to a PII claim.
I understand that.
But that is a factor in the discussion. Yeah,
so I won't ask you how much, but there is a current negotiation over compensation or funds or payments or whatever, however you want to characterise it, for the issuing of further visas.
Yes.
Right, so the Nauruan government's decision to offer further visas is contingent on a financial commitment from the Australian government.
Yeah, there's several elements to the discussion.
But that's one of them.
All of that playing a factor, correct.
Yeah. What are the other elements?
Just timing, the logistics, etc.
Is it the identity or the offending of the cohort a relevant consideration?
Not specifically. Nauru will assess each individual and they'll make a determination about whether they wish to grant them a visa. So they'll consider individual history, for example, on a case-by-case basis as they consider visas.
Right. So they have they said there are particular categories of crime that we're not willing to accept, or?
Not specifically, Senator. They'll consider all cases and determine who they think is appropriate to grant a visa to, if that's the way the arrangement goes.
Okay. Grateful for an update on the numbers, please. The last community protection summary that I've seen publicly released says there's 300 BVR holders in the cohort. Is that still the case today?
That's correct, as of the 28th of February.
Do you have any more recent data, given that that's almost a month ago now?
I don't, Senator, in front of me, but I believe it is a touch higher currently.
At 1, 2, a dozen?
I'm a bit reluctant to guess.
Normally you're able to provide, 2 weeks ago data at Senate estimates, and that's now a month ago, that data.
No, we've endeavoured, Senator, for estimates to come prepared with data up until the end of the month prior.
Right.
So for this estimate, it's the end of February.
We're very close to the end of this month, so it's quite out of date. Will the community protection summary continue to be published during Caretaker?
It will, Senator, yes.
Okay, so when is the next one due to be published?
Where are we? For March, it will be published in sort of early to mid-April.
Okay. How long does it take to collate the statistics for that publication?
Not an extended period, but it does require a degree of manual collation, so it does take some time to get the data together and verify it and cleanse it and do the assurance over it, which is why we do it on a monthly cycle.
Okay, so going from that 300 figure as of the last update, can you tell me how many are subject to electronic monitoring and or a specified curfew?
So of the 300, 70 had electronic monitoring and 42 had a specified curfew.
Okay. Now, obviously, some of those are overlapping.
Yes.
So can you tell me the total number who have neither electronic monitoring or a curfew?
So 230 in total did not have either electronic monitoring or curfew. So everyone that had curfew had electronic monitoring.
Right. That makes sense, but not necessarily everyone who had electronic monitoring has a curfew.
Correct.
What's the difference in a case that requires someone to have electronic monitoring but not a curfew?
It will really come down to the individual circumstances and the delegates' sort of deliberations on the case and what level of risk they present to the community, and the delegate will make a decision about whether curfew, for example, is reasonably necessary for the protection of the community based on that individual circumstances. So
Okay.
each case is considered individually in depth.
Have any of the 230 who are not being either electronically monitored or subject to a curfew been charged with a state or territory offence or committed a visa breach since their release?
Senator, I only have the total numbers of charges, but not broken down by what conditions they had at the time of the charge.
Okay, can you take that aspect on notice?
I can, yes.
And can you give me that breakdown on charges, please?
So again, at the 28th of February, there were 104 current BVR holders that had at least one charge against them since being granted a BVR.
Is that one state and territory offence, or is that also inclusive of visa breaches?
That's inclusive of Migration Act breaches for visa breaches.
Are you able to break it down which ones were visa breaches and which ones were state or territory offences?
I can. So there were 83 people that only had a state and territory charge. There were 7 people that only had a Migration Act charge, and 14 people that had both.
Right. And how many of those, actually let's just do the whole cohort, how many of the total 300 are currently incarcerated in some form?
Again, at the 28th of February, there were 30 people that were in custody at the time.
Yep. And that includes remand?
That does, yes.
And the 3 in immigration detention who are pending deportation?
It does not include the 3 in immigration detention. Right. They're not part of the 300 as they've had their BVR ceased. And
in the Commonwealth's view, they're not NZYQ affected because there's a real prospect of removal.
Okay, fair enough. All right, so we'll treat them separately. Okay. Can you break down the number of the 300 who have a criminal history involving murder or attempted murder?
Of the 300, there were 13 of the individuals.
From memory, at least one of the 3 now in immigration detention was a convicted murderer. So that number would have gone down since they entered immigration detention and no longer NZYQ affected?
Yes, Senator.
Okay. Thank you. Sexually based offending, including child sex offending?
95 people.
Thank you. Assault, violent kidnapping, etc.?
So assault and violent offending, kidnapping and armed robbery, 133.
Thank you. Domestic violence and stalking?
19 people.
Serious drug offending?
24 people.
People smuggling and crimes of serious international concern?
7 people for people smuggling.
And that's also the serious international concern category?
Just people smuggling, so 0 for the...
0 for serious international concern, okay. There was previously someone in that category, wasn't there?
No, it was just a general category that we'd used, but we didn't have anyone in that, which is why we've removed it. So
Okay.
it's not misleading, it's just people smuggling.
It is a slightly mysteriously named category. Low and no level of criminality?
9 people.
9. Thank you. Okay, let me go. Of those now, let me check, 104 who've been charged with state and territory offences or Migration Act breaches, how many of those are for serious violent crimes like murder or assault or similar?
Senator, I don't have the breakdown of specific charges in front of me. I understand there's 0 charges for murder.
That's a start.
There are a number of assault charges and other crimes, but I would have to take it on notice to give you the current specific breakdown of that 104.
If you could, that would be helpful on notice. Okay. Have any of the individuals been released from custody following the completion of a sentence?
Yes, Senator, they have.
How many?
So, at the 28th of February, there were 49 individuals in the community, but that includes both individuals on bail and those that had finalised their charges as well.
Yep. How many of them were on bail and how many had finalised charges?
I'll have to take that on notice, Senator. I don't have a disaggregation of that number
Okay.
across those 2 categories.
I want to go to one specific case. Last week, the AFP published a media release which said a South Sudan-born man was sentenced for visa breaches in Western Australia. He was sentenced for 14 months imprisonment by Perth Court after pleading guilty to 11 visa breaches. The Commonwealth sentence, I'm advised, will start in July following a term of imprisonment. He is already serving for an unrelated number of state offences. But the AFP says, and I quote, "The judge ordered the man to serve 1 month in custody for the Commonwealth offences, then released for the remainder of the terms on a recognizance release order to be of good behaviour." Are you familiar with that case?
Yes, Senator.
I thought there was mandatory minimum for visa breaches. How can you breach a visa 11 times and also be convicted of state offences and only serve 1 month in prison?
Senator, you're correct that there is mandatory minimum sentencing. However, and I think I've spoken to this before with the committee, the judge still retains discretion to suspend sentencing, which it sounds as though is what occurred in this case for some portion of the mandatory minimum. And so a further amendment would be required if the Parliament wanted to remove that judicial flexibility in relation to these provisions.
So it's within the Parliament's power to do that?
It would be available.
Ask a follow-up question.
Please do, Senator Scarr.
From a legal point of view, and we have discussed this, Ms Sharp, before, I don't think anyone sitting in the Parliament, when we passed that law, anticipated that a judge had that residual authority, and I respect the the position of the judge and the judge considering that they do have that authority. Was any consideration given to appealing that decision on the basis that on the face of the statute it's quite clear it's a minimum mandatory penalty and there is no reference to any discretion whatsoever? Did you obtain advice in relation to whether or not it could be appealed?
Well, noting prosecutions aren't my matters, if you like. They're run by the CDPP, so it wouldn't be for Home Affairs to consider appealing. I can take on notice and engage with the CDPP, but that would be a question for the CDPP. Okay.
Well, the second issue then, has the Minister sought any advice, or has any advice been given to the Minister as to whether or not the Act should be amended to close what I consider to be a loophole, and if so, how the Act should be amended?
I think I'd need to take that on notice. I just can't recall off the top of my head the nature of that kind of advice.
I agree with Senator Scarr. It certainly wasn't in my mind as a parliamentarian who supported the passage of the laws that this was possible. I don't recall it coming up in any of the many extensive briefings we had on this matter, or in committee, or in the Parliament. Was the government aware of this risk prior to legislating it?
Senator, I know we all lived that dream at the time, but there wasn't a great deal of time between when the legislation was introduced and I believe the mandatory minimums were put into the Act as part on its way through the Parliament, if I recollect.
But I think the simple answer to your question, Senator, is no, we didn't discuss that. It wasn't highlighted in the passage, and I think we didn't anticipate it.
No. So, but it would be possible, Ms Sharp, in your advice, to amend the legislation to rectify this.
Yeah, and then, yes, amendments would need to, it wouldn't be in the Migration Act, but yes, it is possible for the Parliament to make its intention clearer.
For a specific offence, or does it have to be done more broadly?
Probably it would, we would
be open to the Parliament to do either?
I'd need to go away and have a really good think about that question. I think more typically it would be done on a specific offence.
Senator Patterson, Senator Polly has a brief amount of questions, then we can come back to you before we finish up with Senator Affairs.
Could I just quickly correct something I said?
Of course you can, and you should.
To Senator Patterson. You asked whether anyone was challenging their detention, and I gave you incorrect evidence when I said no.
Right.
In the 6 matters, there are three of the 6 are challenging detention, and I don't mean to be cute, each one of the individual people has one matter challenging detention and one where they're not currently challenging detention.
I see. So they have filed multiple cases in case they're not successful in one instance, or?
Well, they're running multiple. Yes. Some of them. Some of the challenges are to old visa decisions, and some are challenges to the course of action the Commonwealth took in applying for the Nauruan visa.
Okay. All right. Thank you, Chair. Thank you, Chair. I just want to revisit briefly this mandatory minimums issue, and then I'm moving on to a different topic. I might need your assistance again, Ms Sharp. Thank you. It occurs to me that Parliament also recently legislated mandatory minimum sentences in a related area for terrorism offences. Is there a risk that the same problem arises here?
Are you referring to the hate crimes
Correct.
legislation? I think it would be best to ask that question of the Attorney-General's portfolio, who are responsible for that law.
We may not get the opportunity. They're scheduled next week.
Nevertheless,
I don't think it's possible.
I don't advise on that act.
Fair enough. I am concerned, though, that the possibility that Parliament has legislated another defective mandatory minimum scheme that would see someone convicted of a terrorism offence not serve the time the Parliament intended. Anyway, that's not your responsibility. I recognise that. Okay, moving on. I have some questions about the victim link process the Department set up following the NZYQ, that relevant officials are available.
Sorry.
I remember there was an issue with privacy laws and the Department not being able to proactively contact victims. Is that still an issue, or has that been overcome?
No, Senator, that's still the case.
It's still the case. I think this was May last year that we first discussed this. Haven't sought to resolve that issue in the meantime?
Senator, we've been working closely with our state and territory counterparts to ensure that victims have avenues to contact the appropriate sort of area where they contact the department, which is what Victim Link is set up to do, to ensure that if someone contacts the department, we can link them with the right agency, service, etc., to get the support that they require. Typically, it is state and territory law enforcement authorities that have victim details, and they will undertake that engagement as appropriate. Again, it's a privacy matter for us to proactively seek details of victims, especially where they do not want those details to be shared.
Sure. I do appreciate that, but is as a result of that the fact that we're now just reliant on people to reach out to the department? The obligation and the burden is on the victim to make contact.
The department doesn't operate in isolation. So again, we work closely with our state and territory colleagues to ensure that the appropriate entity is having the appropriate contact.
Sure, but how would people even know that this service is available, that there's assistance that you can provide if you can't contact them?
It was really set up to ensure that where people did contact the department directly, that wasn't lost in the department system, and it was referred to the right area that could action and engage with the victim.
So how many victims of NZYQ cohort affected people have been connected to Victim Link?
So at the 31st of January, 5 victims or families of victims had made contact with the department.
It's not a very large number.
No, it's not.
Do we think that others are aware of it and have chosen not to, or is there a possibility that they don't even know this is available?
I think, Senator, we're aware of contact with victims, again, from other agencies, other entities, so it's not that it's not occurring. This is, again, where particularly people have questions for the department or they're unsure about who to contact.
And so, Senator, as Mr Thomas said, we work closely with the entities who do have details of the victims to make sure that they are making our service known, but also so that if they are aware of issues which are departmental issues, that they would connect us up with that. So I don't think it's a question of people not knowing. I think it's a question of the issues that they wish to pursue. They are finding the support through primarily state and territory services.
Yeah. So what support has been provided or assistance has been provided in those 5 instances?
Senator, it will depend on the nature of each specific instance of contact and what the individual was seeking as well. In some cases, people have sought information, particularly around perpetrators. Again, we have privacy restrictions with sharing individual information with people. There's also...
So just to be clear, if a victim of an NZYQ cohort person contacts you and says, I'm fearful for my safety because someone who previously offended against me has been released in a community, can you tell them, are they in my state or territory, are they in my city? What information do you give them?
So this is where we would work with law enforcement so that law enforcement can have an appropriate conversation with them about their safety and any other information that person might need.
But can you answer their question? Can you tell them, don't worry, the person who offended against you is in a different state or territory?
It's much more appropriate for law enforcement to do that. Can
law enforcement tell them that?
Where the situation is appropriate for them to be able to do that, then generally yes, particularly if there are safety concerns or they need to talk to them about circumstances, they can do that where it is appropriate. And I'm
aware of at least one family that has not been able to get that information and is very distressed by it.
And it will depend on individual circumstances and a range of other things, but again, generally, it's a matter for law enforcement to have that conversation with the individuals.
So if you wanted to provide us with the details, we can follow up with the local authorities and see what we can do.
Thank you. I will ask them if they would like to do that. A separate matter is public reporting in the Herald Sun a couple of days ago relating to the Nanette Simons case. Ms Simons spoken about how she feels she's been let down and abandoned after she became a victim, allegedly, of a NZYQ cohort affected person. If you're familiar with this media report,
Yes, Senator.
the report says that the department took over a year to respond to my colleague, Senator Matthew O'Sullivan, who wrote a letter on her behalf seeking assistance. Is that correct?
I'm unaware of the details around the letter. I'd have to take that on notice to check.
Okay, well, I can probably... I don't want to table a copy because it contains personal information, which wouldn't be appropriate, but...
we can check that, Senator.
It was sent on the 12th of July and it was responded to on the 3rd of March, so less than a year, I'm sorry, but still a considerable amount of time for a senator making a representation on behalf of a victim of crime to the department. What is the reason that response took so long?
Senator, when I said I was unaware of the timing and the reasons for it, that's what I'll take on notice to check.
Right. There's an assistant secretary who signed the letter, but it doesn't provide their name, and I wouldn't read it out in this forum anyway, it's not necessary, but do you know who responded to the correspondence from Senator O'Sullivan?
No, Senator.
Right, so you weren't aware that this correspondence has been received?
Again, Senator, I have to check exactly what part of the department would have engaged in that and where it would have come in. But I'll take that on notice to confirm.
Okay.
Patterson, even if you don't want to table that letter, you could provide the official with a copy.
Sure.
Yeah.
Yeah, I'm happy to do that. Okay.